Show on the road, please. Okay. Welcome members to the 7th meeting in 2014 of the Delegated Powers and Law Reform Committee. As always, ask members to switch off mobile phones, an instruction which I will obey myself. Let's put this down here. Apologies have been received from Stuart McMillan and Richard Baker, and I welcome Bruce Crawford as a substitute for Stuart McMillan. Thank you. Agenda item 1 is a decision on taking business in private. It's proposed the committee takes item 6 in private. This is consideration of a draft report on the delegated powers provisions contained in the Housing Scotland Bill at stage 1. Is the committee content to take that in private, please? Thank you. Agenda item 2 is instruments subject to affirmative procedure. No points have been raised by our legal advisers on the Budget Scotland Act 2013 Amendment Order 2014 draft, nor on the Community Care, Personal Care and Nursing Care Scotland Amendment Regulations 2014 draft, nor on the Patient Rights Treatment Time Guarantee Scotland Amendment Regulations 2014 draft, nor on the Renewables Obligation Scotland Amendment Order 2014 draft. The committee may wish to note that the last of these instruments implements a commitment previously given by the Scottish Government to correct an error in the Renewables Obligation Scotland Amendment Order 2013, SSI 2013. 116. Is the committee content with these instruments, please? Thank you. Agenda item 3, instruments subject to negative procedure, and no points have been raised by our legal advisers on the Self-Directed Support Direct Payment Scotland's Regulations 2014, SSI 2014-25, nor on the National Assistance Sums for Personal Requirements Scotland Regulations 2014, SSI 2014-39. Is the committee content with these instruments, please? Thank you. Agenda item 4 is the Disabled Persons Parking Badges Scotland Bill. The purpose of this item is for the committee to consider the delegated powers in the bill at stage 1. In considering the bill, the committee is invited to agree the questions it wishes to raise with the member in charge on the delegated powers in the bill. It is suggested that these questions are raised in written correspondence. The responses received will help to inform a draft report on the bill, and the committee will have an opportunity to consider those responses at a future meeting before the draft report is then considered. Section 1 of the bill amends Section 21(1)(ab) of the Chronically Sick and Disabled Persons Act 1970 to provide that the form of a blue badge issued by a local authority in Scotland must fulfil any requirements specified in regulations or administratively by Scottish ministers. This will allow some elements of the specification to be published in subordinate legislation and some to be set administratively. The bill will amend Section 21 so as to provide that the form of a badge must meet any requirements prescribed by regulations or otherwise specified by the Scottish ministers. The power in the bill is broad enough to allow Scottish ministers to specify the requirements of the badge entirely administratively, without publishing any detail as to the form of the badge in regulations. This would seem to be contrary to the policy intention that non-sensitive features of the badge should be published in regulations, so as to keep such information freely available in the public domain. Does the committee therefore agree to ask the member in charge why he has decided not to draw this power more narrowly, so as to specify generally what requirements are to continue to be prescribed in regulations and what features may be set administratively, and given that the policy intention is explained in the Delegated Powers Memorandum as including that non-sensitive features of the badge should be published in regulations, why the power is drawn broadly to enable the whole specification of the badge requirements administratively if desired. Section 6 allows Scottish ministers to make regulations requiring local authorities to review, on request, a decision not to award a badge on the grounds that a person is not eligible for one. Eligibility depends on being a disabled person of a description prescribed by regulations. The regulations will specify who may apply for a review and the manner in which the application is to be made. The regulations may also provide for the procedure that an authority has to follow when conducting a review. Under Section 6(3), regulations may provide that the review requirement does not apply to a decision that a person is not a disabled person of a description prescribed by the Chronically Sick and Disabled Persons Act 1970 and specified in regulations. The power to exclude certain decisions from review is a wide power that cuts across all decisions on eligibility, yet the Delegated Powers Memorandum does not explain why this power, what this power will be used for. Does the committee therefore agree to ask the member in charge to explain what the power in Section 6(3) of the bill is intended to achieve, and if the power could be used to impose further eligibility criteria for applicants, and why this is considered appropriate?
Agreed.
Thank you. Agenda item 5 is the public... Stuart, sorry.
Sorry, I just wanted to put on the record in relation to the bill something in relation to our access to other legislation, because the bill very substantially is about amending the Chronically Sick and Disabled Persons Act 1970 and in addition the Road Traffic Regulation Act 1984. It's worth making the point that the normal source of legislation already passed is www.legislation.gov.uk that is managed by the UK government. Neither of these acts, as on that website, are up to date, and the references to the sections of these acts that the Disabled Persons Parking Badges Scotland Bill makes are not present in what's available. So therefore it is substantially difficult for those of us who are sitting at the end of an electronic wire over the weekend doing our preparation for this committee to actually know what the effect of this act is. And I just felt it might be useful to put on the record that it would be substantially helpful if the UK government actually kept their legislation up to date on the published record that is available to members of this Parliament.
Indeed, and I think as a chiding to those who may not have been diligent enough to look it up, that may be useful. But it does make the general point that if you can't actually get at the legislation, it's not effective law. And we've said that before. I guess we'll say it again.
I can, Convener, of course, go to SPICE after this meeting and remedy that defect, but it does inhibit one's good preparation for meetings, and I think that's not good order.
John.
I will criticise the UK Parliament. I just want to ascertain that our own Parliament has absolutely got all of its own house absolutely in order and every website is up to date. Perhaps Mr Stevenson could inform us about that.
Well, can I suggest that we don't get into a debate along those lines? But forgive me, Stuart, I think the point is fairly made, but nonetheless the point which I think we should be making is that the general public, of whom we happen to be members in this context, should have access to the current law. And maybe that's the point we could stay with. Okay. Thank you, sir. Right. Can we move on to agenda item 5, which is the Public Bodies Joint Working Scotland Bill? As members will recall, the committee agreed its report on the Public Bodies Joint Working Scotland Bill as amended at stage 2 at last week's meeting. Further to this, the Scottish Government has written to the committee advising it of amendments it had lodged at stage 3, which relate to delegated powers and explaining the purposes of those amendments. Members have seen the correspondence from the Scottish Government and are aware of the briefing that we've just had, and I invite members to comment on what we have before us, please. Does anybody? Stuart?
I'll defer to John.
No, Stuart, thank you.
In relation to Section 46 and the amendments that allow the Scottish ministers to form companies and corporate body, I think there's a very simple shortcoming in the information that's currently before the committee, in that such an amendment being brought forward at stage 3 clearly suggests that something has arisen in the consideration of the bill, or ministers' thoughts around the bill, to bring this forward. But there's nothing before us that helps me understand what reason this is being brought forward. Now, it is a power to cover future events as yet unknown. So in the generality I can understand, but I really think it would be helpful to Parliament if we understood what specific reason the Minister had for bringing this forward. We can see its effect, and we can see the process by which this is undertaken, and I have no concerns on either of those. But I think without knowing the reason why it's being brought forward, there is a shortcoming in our ability to properly understand this.
Thank you. John?
Yes, I mean, I would agree utterly with what Stuart has said on this occasion. And I am concerned that this is being brought forward at stage 3 without the normal parliamentary scrutiny that you would expect. And this is quite far-reaching powers. And I appreciate that there may be policy issues here, but nonetheless, they are certainly far-reaching powers as I understand them. And I think we should have had more information than we currently have to make an evaluation of what the intention is behind this.
Indeed.
I agree we should have more information, but I'm not sure it's as far-reaching as we might imagine it is, because I remember having this very same discussion when the previous legislation which formed Scottish Water came forward, and at that stage challenged the then Labour Liberal executive about whether or not the use of body corporate it was necessarily about forming companies, and at that stage, quite rightly, I was being told by Alan Wilson, who was then the minister, of course, it can be about forming joint ventures with other public bodies, not just outside organisations. So this isn't unusual that the government are now taking this step, although I agree that the committee should have had more information about what its intent and purpose was.
I appreciate that. I think Bruce and I actually sat on that bill committee together, and I remember that and the fact that there is a precedent for this, as Bruce is reminding us. However, the stage 3 of this bill takes place this afternoon, and it's simply not good enough, really. I think that we haven't had more of an explanation, and perhaps, Convener, you might wish to take part in the debate this afternoon to elucidate that information from Government Minister. I don't know that, of course, be a matter for you.
Well, clearly, I think it is a matter of the committee, and if it's a committee concern, then I think it's probably appropriate that the convener takes part and expresses the committee's concerns. But I'd like to hear all of them, because I'm conscious that Mike may have something he wanted to say.
Yeah, it was just really a general point about the timing, in as much as this might be entirely benign or even beneficial. It might be something that we welcome, but the time frame doesn't allow us to explore it, and I think that's a situation that, in general terms, we ought to try and devise a means of avoiding.
Yes. Well, that, of course, is an issue that we've mentioned several times in the last few weeks, and we still have the convener of the appropriate committee listening in, so I'm sure he'll explore that. I think I'm in your hands as to what we should do this afternoon. The obvious thought is that I do, on your behalf, just raise this at the appropriate point when Amendment 86 is called, and simply ask the government if they can say any more about the purpose for which it's there. Noting that if there's any serious policy behind it, then the negative procedure might be one that we wouldn't have expected.
Just for clarity, Commissioner, you used the phrase, and I agree you should use the phrase, on behalf of the committee. So it would be important that we agree that you're not speaking
I think
as an individual.
I think I would be reflecting this morning's
That's
discussion.
Fine. No, I just should be clear about that.
Okay.
Oh, yes.
Okay, well, in which case, I don't want to over-egg it, but I mean, is there anything else that we need to say about that, or has everything that's appropriate actually been said? I think it has.
Just finally saying that perhaps we are the least important part of this process, in as much as the committee itself that's responsible for this bill, and indeed those who have given evidence and others who have scrutinised the bill in the consultation, have not been aware of this. So we are just at the end of the chain here, but there are many others who might have wished to comment on this who will not be able to.
Okay. Right, I think I know what I've got to do. Thank you very much for that. I think at that point that ends our agenda item 5, so we move into private. Thank you very much.